Hello, my lovely people. We're back for part 4 of the Alaska State Constitution. My name is Amanda. I am Gen X Alaska. I am just a nerd who wants to know everything you can know about Alaska. So, starting back with Article 3, we are on Section 26, Boards and Commissions. When a board or commission is at a head of a principal department or a regulatory or quasi-judicial agency, its members shall be appointed by the governor, subject to confirmation by a majority of the members of the legislature in joint session, and may be removed as provided by law. They shall be citizens of the United States. The board or commission may appoint a principal executive officer when authorized by law, but the appointment shall be subject to the approval of the governor. Recess appointments. The governor may make appointments to fill vacancies occurring during a recess of the legislature in offices requiring confirmation by the legislature. The duration of such appointments shall be prescribed by law. Moving on to Article 4, the Judiciary, I can say that, has a little comment section. I'm going to ignore my content. We're going to start with judicial power and jurisdiction. The judicial power of the state is vested in a Supreme Court, a Superior Court, and the courts established by the legislature. The jurisdiction of courts shall be prescribed by law. The courts shall constitute a unified judicial system for operation and administration. Judicial districts shall be established by law. Supreme Court, Part A. The Supreme Court shall be the highest court of the state with final appellate jurisdiction. It shall consist of 3 justices, one of whom is Chief Justice. The number of justices may be increased by law upon the request of the Supreme Court. Part B. The Chief Justice shall be selected from among the justices of the Supreme Court by a majority vote of the justices. His term of office as Chief Justice is 3 years. A justice may serve more than 1 term as Chief Justice, but he may not serve consecutive terms in that office. Amended 1970. Superior Court. The Superior Court shall be the trial court of general jurisdiction and shall consist of 5 judges. The number of judges may be changed by law. Qualifications of justices and judges. Supreme Court justices and Superior Court judges shall be citizens of the United States and of the state, licensed to practice law in the state, and possessing any additional qualifications prescribed by law. Judges of other courts shall be selected in a manner for terms and with qualifications prescribed by law. Nomination and appointment. The governor shall fill any vacancy in an office of Supreme Court Justice or Superior Court Judge by appointing one of 2 or more persons nominated by the Judicial Council. Approval or rejection. Each Supreme Court Justice and Superior Court Judge shall, in the manner provided by law, be subject to approval or rejection on a nonpartisan ballot at the first general election held more than 3 years after his appointment. Therefore, each Supreme Court Justice shall be subject to approval or rejection in a like manner every 10th year, and each Superior Court Judge every 6th year. Vacancy. The office of any Supreme Court Justice or Superior Court Judge becomes vacant 90 days after the election at which he is rejected by a majority of those voting on the question, or for which he fails to file his declaration of candidacy to succeed himself. Judicial Council. The Judicial Council shall consist of 7 members. 3 attorney members shall be appointed for 6-year terms by the governing body of the organized state bar. 3 non-attorney members shall be appointed for 6-year terms by the governor, subject to confirmation by a majority of the members of the legislature in joint session. Vacancies shall be filled for the unexpired term in like manner. Appointments shall be made with due consideration to area representation and without regard to political affiliation. The Chief Justice of the Supreme Court shall be ex officio the 7th member and chairman of the Judicial Council. No member of the Judicial Council, except the Chief Justice, may hold any other office or position of profit under the United States or the state. The Judicial Council shall act by concurrence of 4 or more members and according to rules which it adopts. Additional duties. The Judicial Council shall conduct studies for improvement of the administration of justice and make reports and recommendations to the Supreme Court and to the legislature at intervals of not more than 2 years. The Judicial Council shall perform other duties assigned by law. Commission on Judicial Conduct. The Commission on Judicial Conduct shall consist of 9 members as follows: 3 persons who are justices or judges of state courts elected by the justice and judges of state courts, 3 members who have practiced law in this state for 10 years, appointed by the governor from nominations made by the governing body of the organized bar and subject to confirmation by a majority of the members of the legislature in joint session, and 3 persons who are not judges, retired judges, or members of the state bar, appointed by the governor and subject to confirmation by a majority of the members of the legislature in joint session. In addition to being subject to impeachment under Section 12 of this article, a justice or judge may be disqualified from acting as such and may be suspended, removed from office, retired, or censured by the Supreme Court upon the recommendation of the Commission. The powers and duties of the Commission and the basis for judicial disqualification shall be established by law. Retirement. Justices and judges shall be retired at the age of 70, except as provided in this article. The basis and amount of retirement pay shall be prescribed by law. Retired judges shall Judiciary 20 render, I think that's a typo, no further service on the bench except for special assignments as provided by court rule. Impeachment. Impeachment of any justice or judge for malfeasance or misfeasance in the performance of his official duties shall be according to procedure prescribed for civil officers. Compensation. Justices, judges, and members of the Judicial Council and the Commission on Judicial Qualifications shall receive compensation as prescribed by law. Compensation of justices and judges shall not be diminished during their terms of office unless by general law applying to all salaried officers of the state. Amended 1968. Restrictions. Supreme Court justices and Superior Court judges, while holding office, may not practice law, hold office in a political party, or hold any other office or position of profit under the United States, the state, or its political subdivisions. Any Supreme Court justice or Superior Court judge filing for another elective public office forfeits his judicial position. Rule-making power. The Supreme Court shall make and promulgate rules governing the administration of all courts. It shall make and promulgate rules governing practice and procedure in civil and criminal cases in all courts. These rules may be changed by the legislature by 2/3 vote of the members elected to each house. Court administration. The Chief Justice of the Supreme Court shall be the administrative head of all courts. He may assign judges from one court or division thereof to another for temporary service. The Chief Justice shall, with the approval of the Supreme Court, appoint an administrative director to serve at the pleasure of the Supreme Court and to supervise the administrative operations of the judicial system. Amended 1970. Moving on to Article 5, Suffrage and Elections. Qualified voters. Every citizen of the United States who is at least 18 years of age, who meets registration residency requirements, which may be prescribed by law, and who is qualified to vote under this article, may vote in any state or local election. A voter shall have been, immediately preceding the election, a 30-day resident of the election district in which he seeks to vote, except that for purposes of voting for President and Vice President of the United States, other residency requirements may be prescribed by law. Additional voting qualifications may be prescribed by law for bond issue elections of political subdivisions, amended in 1966, 1970, and 1972. Disqualifications. No person may vote who has been convicted of a felony involving moral turpitude unless his civil rights have been restored. No person may vote who has been judicially determined to be of unsound mind unless the disability has been removed. Methods of voting, election contests. Methods of voting, including absentee voting, shall be prescribed by law. Secrecy of voting shall be preserved. The procedure for determining election contests with right of appeal to the courts shall be prescribed by law. Voting precincts registration. The legislature may provide a system of permanent registration of voters and may establish voting precincts within election districts. General elections. General elections shall be held on the second Tuesday in October of every even-numbered year, but the month and day may be changed by law. Editor's note. Exercising its authority under this section, the legislature has provided that the date of general elections is the Tuesday after the first Monday in November in every even-numbered year. And that's all for this part 4. I'm Amanda, Gen X Alaska, just a nerd who wants to know everything I can about Alaska. And join me in part 5 as we continue reading the Constitution of the State of Alaska. And as usual, you have to watch me walk off because I don't want to edit. Love ya.